How you doing?
I'm good, thank you. What's your name, sir?
If I can help you.
I'm Williams L.
Yes, Your Honor, but the defendant is identified in the docket as Michael Williams. Is that correct, sir?
Yes, that's the name they're calling me, but I am
Okay.
Williams L.
I understand.
Michael Williams. Okay.
No,
Mr.
I'm not
Williams, I'm
Michael
asking-
Williams. Your Honor,
Okay.
I am.
So here's the thing, Williams L. I have to call you what's on the documents that I have present for me in court today. We can either handle it that way, or you don't have to handle it, and then it just will be like you didn't show up to court today.
No,
So it's
Your
either
Honor,
way,
I'm just
but I
letting
have
you
to
know
call
who I. Your Honor, I'm just letting you know who I am.
Okay.
I am Williams
That's fine.
L. I am not Michael Williams. They kept calling me Michael Williams. I told them who I was. I am a sovereign, Moorish American. I'm not United States citizen, Negro, Black, or colored, Your Honor.
Okay, so let me tell you, Mr. Williams, this is the last time I'm gonna say it. This is all I have for you. If you don't want to handle it under that name today, then I have to act as if you aren't present, and so that's fine. But I
You
have
say
to
what?
call
Hold
you
on.
what's that document, okay?
Can you repeat that? Can you repeat that,
I
Your Honor?
said, if we can't handle those matters and those tickets that's on that case under that name, then that's fine. But it's going to be as if you didn't appear for court today because I have.
Ma'am, I'm here today, ma'am.
Right. So I'm just saying when I
Williams
call those
L. is
What you're about to witness is a masterclass in how sovereign citizen ideology collapses the moment it meets real courtroom procedure. This case involves a Moorish American defendant who believes rejecting the name on the docket somehow erases the court's authority over him. Instead of resolving traffic-related charges and bench warrants, he turns a routine appearance into a procedural standoff, one that the law is fully prepared to win. This video actually covers two separate court appearances, and in both, you'll see the same pattern repeat. Identity games, refusal to participate, and absolute confidence paired with zero legal grounding. The judge remains calm, direct, and patient, while the defendant insists that presence alone equals participation. Spoiler alert, it doesn't. As this unfolds, pay close attention to how quickly rights turn into liabilities when someone refuses to engage with the system they're standing inside. Because by the end of this video, you'll see how refusing a name doesn't make charges disappear. It makes warrants stick around longer.
So that's fine. When I call it on the record, I'm going to have to call it on the record as the name on the ticket, just so you know, okay?
Okay, and I'm gonna let you know that I'm Williams L. Okay, I'm cool
That's
with
fine.
that, and I'm letting you know who I am. I'm a
Okay.
Moorish American.
Okay. Did you want to
Sovereign.
offer? Okay. Did you want to offer for it or no? Are you going to try and have? I need to kind of know where you're going. Are you going to want a trial? Are you going to try and want to?
No, I do not agree. I do not agree to none of this. I'm sovereign.
Okay, so if you're not going to participate, we're just going to act like you're not here today, and I'm going to go ahead and.
I am
say-
here today, ma'am. You seeing me right here? That's on
You
record.
have to- Listen, just because you show up doesn't mean that you're here. You have to participate, okay?
Ma'am, I'm a sovereign. I'm letting you know who I am.
Listen,
I'm participating. I do not
and
agree.
Mr. Williams, that's fine, but if you don't participate, saying
That's violating the constitutional right, ma'am.
so, do you want an offer or not? That's my question.
Do I want to what?
An offer to the tickets or not?
Do I want to? I can't understand. You said, do I want to offer?
Do you want an
tickets?
offer? Do you want to try and resolve this today as far as
Yes,
the offer?
I do want to resolve it. I asked for this case to be dismissed off lack of jurisdiction, Your Honor.
Oh, no, that's not going to happen. So you can, I'm
Well,
not going to.
I'm just, well, I'm speaking for myself. I have no attorney, so I'm speaking for myself. I asked for this case to be dismissed. You're violating my constitutional right.
How do
And
you
I
have
asked for your
constitutional
oath of
rights if
office.
you're not a citizen?
I'm not a United States citizen.
So how are you entitled to constitutional rights of citizens?
This is one of the most common sovereign citizen tactics, and it fails every single time. By claiming to be Williams L. instead of Michael Williams, the defendant believes he's severing legal responsibility from himself. But courts don't operate on self-declared identities. They operate on records, physical presence, and jurisdiction. The judge immediately identifies the flaw. The person physically standing in front of the court is the same individual named on the ticket. Whether he likes the name or not is irrelevant. Legal identity isn't optional, and you don't get to opt out by rebranding yourself mid-hearing. What makes this especially damaging is that the defendant thinks he's being precise and strategic, when in reality, he's burning credibility in the opening minutes. From this point forward, every word he says is filtered through the lens of non-participation.
You got to uphold to the sovereign, sir. You can't. I'm not United States citizen. I'm not Negro, black, or color. You're not under I'm not under your jurisdiction.
I understand, but my question to you is, if you want to rely on your constitutional rights, how do you have constitutional rights if you're denying your citizenship?
Yeah, because I'm an American. I'm a national.
I get
I'm
it,
a
but
Moorish American. I'm not United States citizen corporate. I'm a Moorish American. I'm an American national.
okay, but you're still present in this jurisdiction, right? Right.
What am I doing here?
He can represent himself. Don't worry about it. You put
I can
yourself on
speak
record.
for myself.
All right.
I'm speaking
Now
for
calling the
myself.
matters
Y'all
of the
violating my
people.
rights as a
Now
sovereign.
calling the matters of the people versus Michael Williams. This is ticket number SP12123334. Count 1, use loudspeaker without permission or unreasonable noise. Count 2, drove while license suspended. Count 3, no insurance misdemeanor. Sir, please state your name for the record.
I am Williams L.
All right. Sir,
I don't have a name. I have a title.
This is the date and time set for an arraignment on a bench warrant. Do you want to participate in these proceedings?
Yes, I'm here on special appearance. I'm just letting you know who I am.
All right, so how would you like to move forward with this matter, sir?
I asked for this case to be dismissed off lack of jurisdiction, Your Honor.
All right, that motion has been denied. How would you like to move forward on these matters?
I just told you what I would like it, so I don't know. I'm just here on
So it's
special
been
appearance.
denied, so you can either participate today.
I am participating.
This is the moment where the judge lays out the consequences plainly and legally. Participation doesn't mean standing in the room. It means answering questions, responding to charges, and engaging with procedure. The court is not required to chase someone who refuses to take part. The warning is crystal clear. If he won't proceed under the name on the docket, the court will treat it as a failure to appear. That's not a threat, that's procedure. And the defendant's insistence that Williams is here completely misses the point. The court isn't confused about who he claims to be. It's concerned with whether the charged individual is participating.
So I'm just letting you know. It's denied, so we can keep going on with proceedings. I am Williams L. I'm not a United States citizen. I'm not Negro, black, or color. I'm not Christian.
All right, Mr. Williams, it appears to the court as I'm making a record that he does not want to participate in these proceedings.
I told you I wanted to
dismiss these
participate. I'm just
matters.
letting you know who I am. I told you for the record.
All right, he would like to not participate in these proceedings. He has told me that he is the person known as Williams L. and not the person on these tickets, so he is not appearing on behalf of this person. This person has not made themselves available to the court today as an arraignment on the bench warrant, so these matters will stay in warrant status. Thank you so much. That concludes this hearing. Have a good day, Mr. Williams L. I'm gonna call the case as is.
Okay.
And then I'll refer to you as Williams L if you would like, okay? Now calling the matters of the people versus Michael Williams, also known as Williams L. This is ticket number SP12123334. Count 1, use loudspeaker without permission or unreasonable noise. Count 2, drove while license suspended. And count 3 is no insurance misdemeanor. Sir, can you state your name for the record, please?
Williams L.
Okay. And is there another name that you have?
That's not my name. That's my
Okay. What's your title that you have, sir?
Williams L.
And then is that your name or your title?
My title.
Okay. You don't have a name at all.
No,
I'm
not Christian.
All right. It's my understanding that you don't want to have an attorney, sir. Is that correct?
Yes, sir.
Now, you know you have the right to have an attorney. These matters are misdemeanor matters, and you have the right to have an attorney on these matters, sir. And it's my understanding, no attorney, okay? So let me advise you of your rights. In these particular matters, the court can, since they are misdemeanors, do either, I think, 90 days on one of these and up to 93 days in jail, or a maximum fine of $500. These are all misdemeanors, so that's the maximum penalty that can be given in any of these matters. You have a right to have a trial, a bench, or a jury trial in any of these matters. A bench trial is a trial before myself as the trier and finder of facts. A jury trial is a trial with 6 members of the city of Detroit who will come in here and hear the same information and make a decision based on that. These are your rights that you have right now. You also have a right to have a pretrial. What that does is that gives you time to think about any offer that may be given to you. At this point in time, there has been an offer extended to you that if you are willing to plead to the no insurance misdemeanor, it will be reduced to an improper place. I set the fine that goes with that. You have a right to, you can also move for a motion. If you know how to file those, you can file a motion as well. So what's your pleasure at this time, sir?
I know I'm under common law.
Declaring oneself a sovereign Moorish American doesn't change jurisdiction, dismiss charges, or override local court authority. Judges hear this exact language constantly, and the law has already addressed it repeatedly. What's happening here is not a legal argument. It's a philosophical declaration. And philosophy doesn't trump statutes. The judge doesn't debate identity politics or historical narratives because none of that determines whether a traffic violation occurred or a warrant exists. Instead of strengthening his position, this rhetoric isolates him further. Every time he repeats it, he reinforces the record that he's refusing to participate under the legal identity charged, which sets the stage for exactly what happens next.
City street in the city of Detroit, any road in the state of Michigan, you now avail yourselves, whether you wanted to or not, to the laws and states and regulations that are governing us. So you may not have wanted to, but you did. So these are your options at this point in time. If you choose not to, if you were traveling, if you were driving, it's all the same.
I wasn't driving. I was never.
So if you were just in the vehicle as a passenger.
I was parked. And they was harassing.
You sure you don't want an attorney?
I'm under common law. I can speak for myself. I'm not a minority. I'm a sovereign.
So what option would you like today? Of those that I gave you, sir. You can have.
Ma'am, I'm a sovereign. I can't, I do not consent. I can't. I can't
so here's
consent.
what's gonna happen. So I want to make sure you have all the options. You can't consent to anything. So that means that you don't want to participate in the process. So it's just gonna go back into warrant status because you have to pick one of the options. Yes.
Ma'am, I'm a sovereign.
And you were in the city of Detroit on a street in a vehicle. And I understand what you just said. That's why I said, right. Did you want counsel?
I'm not a United States citizen.
Okay. All right.
Nobody have improved jurisdiction. I'm a Moor. Nobody have improved jurisdiction. I'm under common law. Statutes don't apply to me. I'm under common law. Supreme Court case. Supreme Court case, Self versus Ray. Statutes don't apply to me. I'm on common law. And if there was a crime committed, can you please show me the injured party? Or I ask for this case to be dismissed off record jurisdiction.
I deny the motion for the case to be dismissed, so you have these options, or else it's just gonna remain.
And I'm under duress because you forced me saying you're gonna put a warrant out for my arrest.
It's already out there.
But that's violating my 13th Amendment. You can't enslave me unless a crime is being committed.
So you can't
violate my
constitutional
right.
Let me finish talking. You can't claim you're sovereign and then claim rights under the Constitution. That's not how it works. No, that is not how it works.
Ma'am, I'm not a United States citizen. I have a nationality.
Okay, so that means that
you have to go by
either the laws all apply or none of them apply.
The laws do apply. What, do you have a liability? Do you have a bond? Did you swear oath to the Constitution? I would like to see that.
Yeah, I was about to say I did do that, but I don't have to show you any of that because I wasn't the arresting party. I'm just here to make sure.
Do you have a liability? Do you have a bond?
I'm not going to argue with you, Mr.
I'm not arguing. I'm under law.
Mr. Williams L. Those are your options. If you don't want any of those options, it's going to remain in warrant status.
You're forcing me. You can't do that.
Okay.
You can't do that, man.
Right.
You can't go against Constitution.
Okay, Mr.
You took an oath.
Williams-L.
You swore an oath to follow the Constitution.
I did.
That's why I need your liability bond. Do you have a liability bond?
No.
You don't have a liability bond?
No.
Wow, man. Somebody's going to get in trouble. I'm not trying to get nobody in trouble.
This exchange exposes one of the biggest contradictions in sovereign citizen ideology. On one hand, the defendant denies U.S. citizenship and jurisdiction. On the other, he demands constitutional protections that apply within that same legal framework. The judge cuts straight through the confusion by asking a simple question. If you deny citizenship, how are you asserting constitutional rights tied to that system? The answer never comes, because there isn't one. While basic human rights like due process apply broadly, specific procedural rights exist within defined legal systems. Courts don't operate on selective participation. You don't get to reject authority while demanding its benefits. And this contradiction completely undermines his position on the record.
Okay.
Okay.
Mr. Williams L., I was about to say, if you don't want any of those options, then your only other option is that I have to leave it in warrant status.
I do not consent. I'm here. What warrant? That I didn't show up?
That you didn't want to choose one of these things.
I don't have to. You can't force me to do that, Your Honor.
You're right.
You can't force me. You can't put a warrant. I would like to talk to somebody, a chief judge. You're violating my constitutional rights.
You go to the fifth floor and make a complaint.
That's because you're violating my constitutional rights.
All right.
And I'm gonna ask the sheriff for your liability bond.
Okay.
Hey, I don't want to do that.
Okay, you can ask him. Go ahead and ask the sheriff for my liability bond. It's fine.
You took an oath to swear to the Constitution. You took an oath. I'm under common law. I'm not under statutes or regulations.
Okay. Thank you, Mr. Did you get all that, Miss Sandy? Okay, fantastic. All right, that concludes this hearing. Thank you so much.
I'm not Negro, black, or color for the record.
Okay. He said he's not black or color for the record either, okay?
No, I'm Moorish American. I'm a Moorish.
Moorish American, and he's a sovereign.
I have a nationality.
Any authority to act on behalf of Matthew Aldridge in this court. You have no legal authority, nor do you have any authority through a legal document to represent or to act on behalf of Matthew Aldridge. Show it to the bailiff and he'll show it to me. Oh, apparently there's a copy here. All right, this is in the state of Tennessee of Cheatham County and Chancery Court, which is filed in the wrong county because in the wrong court, because this is circuit court. You just be quiet.
You go to the courthouse, it comes up.
You need to listen to me instead of talking, okay? This is a challenge to the standing. The Supreme Court of the United States has stated that no corporation has standing anything to man. And then there's a quotation for Rundle versus Delaware Raritan Canal Company. And then it said, as well as it being a maximum of law, citing certain
This is the unavoidable result of refusing to engage. When a defendant won't acknowledge the identity charged, the court has no choice but to treat the case as unresolved. That means warrants stay active, deadlines don't move, and nothing gets fixed. Notice the judge's language: calm, procedural, and final. The court isn't punishing him emotionally. It's documenting non-participation and moving on. That's how the system works. This is why these tactics backfire so badly. Instead of clearing warrants, the defendant preserves them. Instead of resolving charges, he guarantees they return later, often with harsher consequences attached.
Latin phrases, dissimilar things ought not to be joined by a definition of Black's Law Dictionary. So the respondent in error requires that the state of Tennessee Incorporated and Cheatham County Chancery Court prove their standing to proceed against a man in any court of law. You have 15 calendar days to prove your standing or forever yield to estoppel, waiver, and fraud, and cease and desist this proceeding immediately. More time is available if requested. And then this was signed by Matthew O'Neill Aldridge. Is that your signature?
That's the respondent in error signature.
All right. Well, I find that Matthew Neil Aldridge has failed to appear in personally in this court for the plea day on his case, which is set for trial tomorrow. And as a result, you have no standing, sir, under what I know what you're trying to do is to try to use the sovereign citizen approach to this situation. And I'm simply telling you that you do not have the right to represent Matthew Neil Aldridge. If you are in fact Matthew Neil Aldridge, then you need to say so and stop this nonsense, because what you're attempting to do has no legal effect. You cannot challenge the criminal law or the jurisdiction of this court by simply filing some legal mumbo jumbo having to do with civil litigation. That has civil litigation in it. It is not a criminal case that you have cited. So it has no effect on this court. regarding the criminal statutes of this court. This court is empowered under the Constitution of the United States of America and the Constitution of the State of Tennessee and by the duly elected citizens of Cheatham County to empower and enforce the laws of the state of Tennessee. And that is what I'm going to do regarding Matthew Lynn Aldridge. Mr. Aldridge is set for today to appear in court personally on our last plea day before his trial date tomorrow.
Is that an article 3 trial?
To what?
Would that be an article 3 trial? A trial by jury with jury?
It would be a trial by jury, certainly it would be. But I don't know who you are. And I don't think you have any authority if you are not Matthew Lynn Aldridge to appear before this court. And you're wasting valuable time to all of these other citizens who are here today. So when I'm talking, you stop talking. No, you will when I'm finished talking. You are wasting the court's time by doing this, and I'm just simply instructing you that if you are in fact Matthew Lynn Aldridge, then this is your last day to settle your case. The trial date is set for tomorrow, and unfortunately it will not go forward because of the fact that I have a conflict and I have to be in Stewart County on a civil matter. So we're going to assign a new trial date for Matthew Lynn Aldridge. Now, is there a problem with the jury warrant? I'm going to put a notice up there and read you on February the 6th. Right. To Matthew Aldridge and the individual standing before me whose name must not be uttered, then we will set a July 15th trial date for Mr. Aldridge. Whatever this document is that you have filed is in fact invalid because it does not cite any valid criminal statute, and therefore I'm denying whatever that might be in the way of a motion. The trial date will be July 15th. The last day for Mr. Aldridge to enter a plea or go to trial will be July the 8th. July the 8th. Now, we're going to give you a card. If you are in fact Matthew Aldridge and you're just playing games with the court regarding this nonsense that you filed, then you may get his card and you may go on about your business. If you are not Matthew Aldridge, then I would suggest to you, you relay to Mr. Aldridge that he must appear on July the 8th, or a bond revocation will take place, and his case will be will take place with him in jail, incarcerated on the 15th. That's the judgment of the court. You need to take your piece of paper and go on about your business.